Hello, everyone, and welcome back to another Saltivation video. Today, we wanted to talk about House Bill H.R. 8021, and this would be some language modification to Public Law 86272, which, for those of you who may or may not follow Saltivation, Stacey and I talk about a fair amount and are actually getting ready to present on this in a couple days. Do an entire 2-hour webinar on that. So to start out, this bill was introduced in the House on April 16th by Representative Scott Fitzgerald, a Republican out of Wisconsin. And so I'm just going to read it because it is very short. And so at the crux of it, the bill is to kind of add to the definition that the term, quote, solicitation of orders means any business activity that facilitates the solicitation of orders, even if that activity may also serve some independently valuable business function apart from solicitation. So, Stacey, what do you think that means?
Well, to take a little bit of a step back, for those of you that have been, paying attention, or maybe those of you who haven't, well, this might be news, but in August of 2021, the Multistate Tax Commission put out an expanded, I would say, interpretation of what Public Law 86272 may actually not protect. And in it, this expanded interpretation looked to interactive websites specifically. And what does an interactive website mean? The examples that the MTC used as failing any kind of public law 86272 protection would be chat boxes, for example, where there was somebody on the other side potentially troubleshooting an issue for somebody, or having an employment application online that a company would host, and a potential applicant could go in, apply for the job, submit it through the online application, and then cookies. So how many times do you go into a website and the cookie prompt comes up and you may or may not pay attention to it? You could accept all cookies. And if those cookies are being used for something other than just soliciting the sale of an order, then those kind of activities could then not be protected under Public Law 86272. So fast forward, and some of you may have, seen California was first to the gates with saying, we're going to attempt to pass this, and this is our new expanded interpretation of Public Law 86272 as well. It went through litigation, and it was really more of a technicality where the taxpayer won because California didn't really go through the right administrative process in order to pass that legislation. But in the intervening time, we've seen New York pass it, we've seen New Jersey pass it, we've seen some other states consider it. So here we are now, where we've got the MTC saying this has been an expanded interpretation. It's not necessarily new law. And some states are saying, hey, we kind of like this. And we've got taxpayers then that are having to grapple with it. Well, luckily now we've got this bill that was introduced to the House, as Meredith said, but it comes with probably some even interpretations of its own. And what we think, the intent here is to say, okay, you can do some of these interactive website activities, whether it's cookies, whether it's chat boxes, et cetera, and not necessarily lose that Public Law 86272 protection because of the fact that our suggestion is to broaden the definition of what is, quote, solicitation of orders. So that's the hope. However, like I said, I mean, as Meredith said, or she regurgitated the, verbiage from the bill. It's very brief. And as we all know, words matter and the meaning of words matter. And so I think this is a really nice attempt to try to broaden that definition of solicitation of orders. However, I think we've got a lot more work to do, and there's going to be um, a lot of legislation, or hopefully a lot of
Right.
legislation, that then this opens the door for, I guess, is the point I'm trying to make. So, but we all know that there's been many bills that have been introduced over time, some tax related, some not, and they don't go anywhere. So it remains to be seen what happens with this. Hopefully something. And we do have other litigation in New York that the ACMA, who was the party that also took up the litigation with California, they are taking this up with New York. So maybe that, coupled with the fact that we do have this bill, will get some traction. But it's June as you and I are recording, so it remains to be seen, I guess, what will ultimately happen.
Yeah, and right, because 86272 is a federal law. And I think this is an argument even in the ACMA case in New York, where any changes to this need to be enacted by the federal government and shouldn't be, taken up with the states. So this is, I think, a response to, hey, everyone says Congress needs to act in order to kind of make modifications to 86272. And so I think that's kind of, would you say maybe that's why this could be a big deal, right? Because this is part of that, like, everyone keeps saying states can't change it, states can't change it.
Correct.
Has to be done at the federal level. And this is a way to kind of protect that kind of ability to not have to create that income tax responsibility for these internet activities as part of this, revised amendment.
No, absolutely. And that law, Public Law 86272, was passed in 1959. And there have been interpretations along the way. We know that solicitation was very much reviewed, defined, honed in on in the Wrigley case from 1992, but by and large, the solicitation piece has not changed since then. And so this is, another, I guess, look at what is solicitation and what does that mean, that potentially could be litigated. But I think, to your point, the crux of the matter is, can we have these states, take a look, or take an interpretation of a federal law that it doesn't say anything
suggesting
about,
that, a chat box is beyond solicitation.
And again, the states would say, and the MTC would say, well, it was passed in 1959, so our economy,
no one knew.
Nobody had contemplated anything about a chat box, or the fact that you and I are even talking right now on computers. So yeah, understood. But at the same time, it does seem like a sweeping interpretation change. And we're hoping that this bill will get traction and have Congress, take a look at it, because it is a potentially bigger issue. And if these activities that are interactive in nature, or, so-called interactive in nature online, fail Public Law 86272, we think about the number of businesses that have these kind of activities on their websites. I mean, it's almost every potential vendor who has a website has some kind of interactivity. So they're going to be subject to income tax in lots of different states potentially. So it's a big potential change and a big potential issue that, again, hopefully with this bill will raise awareness, as well as then get some attention.
Yeah. So I guess as of the date of this recording in mid-June, it still sits. It was introduced on April 16th, referred to the House Committee on the Judiciary that same day, and there it sits. So I guess, we'll say thank you to, I guess, the Republican House member who introduced this, and it has 3 co-sponsors, all from the state of Wisconsin, close to Stacey and I's home state. So we will follow it. Hopefully it moves, but it's probably going to be one of those things that'll stall, unfortunately. But as we know more, you all will know more. So thank you for stopping by and listening to our Saltivation video this round. Till next time.